Subhashini Ali, the left parties have said various things about Justice Ganguly, about the motives of this entire case, about what's been happening in terms of proceedings, the things that Justice Ganguly himself has said. What do you feel, Ms. Ali, about the action that's been taken by the government today?
Well, I think that we have to keep two things completely separate. That is that Justice Ganguly as a judge and the judgments he gave, that's a completely separate issue.
Absolutely.
And many people have supported that and welcomed it. And as the chairperson of the Human Rights Commission also, he has done good things that have been appreciated. But the seriousness of the charges that have been made against him by the young intern and the fact that the three judges of the Supreme Court went into the whole matter in great detail and came to the conclusion that prima facie her charges could be upheld. That was a very serious matter.
Absolutely.
One cannot excuse a person occupying that kind of a high position, behaving in this way, and therefore he should have actually resigned a long time ago. He could have said he was innocent, an inquiry could have been held, but he should have certainly resigned. That was the correct thing for him to have done, and that is what people were expecting him to do. You see, the matter is really very serious.
Yes.
Because it's not just a girl making an allegation. It was caught on CCTVs. He was seen running after her. So there was evidence backing up what she was saying, and therefore the three judges also took it very seriously and came to that conclusion. After that, there was absolutely no reason for him to have stayed in office.
Mr. Tulsi, one perception is also that it has taken too long a time for this action to actually be taken by the government. What is your view on what the Union Cabinet decided to do today?
Well, I think what the Union Cabinet decides may end up as an exercise in futility, because Section 23 of the Protection of Human Rights Act of 1993, in fact in subsection 1 does talk about the proved misbehavior. Now, proved misbehavior under subsection 1 has been made subject to the provisions of subsection 2, and when subsection 2 opens, it says notwithstanding anything contained in subsection 1.
Okay.
And proved misbehavior is then defined only which takes place upon conviction of a criminal offense.
Okay.
Now, in this case, there is no conviction, and the other two allegations that have been made are with regard to this is not paid employment. If he has endeavored to sort out the issues between the football club.
Yes, you're talking about the other set of allegations which was there in the cabinet note today. Yes, go on.
That's right.
Yes.
And also the fact that he has gone to Pakistan and has no prior approval has been taken is a mere technicality. This cannot fall in any of the clauses of proved misbehavior under subsection 2.
Okay.
And I think that there is a serious mistake in the drafting of section 23, and that's why I say that it may turn out to be an exercise in futility. It's not free of debate, and you cannot now assume at this very stage that this is an end game.
Okay, so there are no absolutes is what you're saying right now. This cannot be interpreted as an end game. Karuna Nandi, you've said more than once when we've had you on this story on our channel and others that it's time for Justice Ganguly to resign. He should resign. He should take responsibility and resign and let an investigation happen. Given some of the things that have been said by the speakers before you, what would you say about the government choosing to do what it did today, nearly 2 months after those allegations first surfaced?
The government has done the right thing today. And the government, what Mr. Tulsi was saying about Section 23, in fact points to the fact that a criminal investigation must also be, has also been long overdue, right? Because at the moment the police has not taken any action, even though a finding by 3 judges of the Supreme Court, based on the evidence that is currently there, has been made a prima facie finding that physical sexual assault happened. Right? Now, this is very different from sexual harassment. This is now section 354, which is cognizable. So, look, I think a lot of this points to the importance of structural reform.
Yes.
Why is all this happening now? because we are not expecting a criminal judgment anytime soon. If Justice Ganguly and others knew that a criminal determination would happen soon, if he had great confidence in his own innocence, and which he seems to have, otherwise, I mean, surely he would have stepped down, right? Why not have a criminal investigation and do it fast? This is what the law currently is. Now, yes, there is perhaps a larger discussion to be had, which is that where the victim or the person who has suffered the sexual assault is sufficiently empowered, where there is no caste or communal violence, where a magistrate determines that the young woman is sufficiently empowered and she decides that the criminal case should not be taken forward, that is perhaps a scenario that can be, that must be discussed actually. But at the moment, the law is this. The law is that when there is a cognizable offence, a police investigation must take place, and where the police knows about it, and then there's a determination. Now, the government having to go through a presidential reference and having to refer this matter to the Supreme Court is startling to me. Because where, Justice Ganguly is not just saving his own skin or saving his own image, you see, regardless of whether he's innocent or guilty. What he is doing is he is taking away from the people of West Bengal a fair forum. And a fair forum is one that is not only not biased, it has to be seen not to be biased.
Sanjay,
there was a couple of weeks ago. There
Sanjay,
was a complaint of sexual harassment that came before the West Bengal Human Rights Commission. And what perception of fairness can there be then?
The point is taken.
You have a 16-year-old girl, and if that matter had come before then, what would have happened?
Your point is taken, Karuna. Sanjay Hegde, I want to bring you in at this point. You've heard what your colleagues from the Supreme Court have had to say, as well as what Subhashini Ali has had to say. Your opening comment on what the government did today.
The government move was expected.
It was in the pipeline.
There was a complaint from the West Bengal government. The government has just copied all the allegations, decided that, okay, we shall start a presidential reference. Now, this is only the beginning of the process, because the presidential reference is one of the 4 things which is mentioned in Section 23. There has to be proved misbehavior or incapacity on a reference, after an inquiry, and a report being made by the Supreme Court. So this is the first step. As to whether Justice Ganguly should resign or not, I would leave it to his conscience. And after all, let's consider the possibility that Justice Ganguly believes that he did nothing, that he is innocent, and he wants a forum to prove his innocence. Where else can he go? When the allegations are made and there is a reference, he will answer the reference. That is the correct forum. Now, of course, the question arises: should he, on moral grounds, quit, etc.?
That is a larger question.
That's a larger question. It's a philosophical question. Let me turn it around. If this is to be followed, everywhere you will see that the moment that there is inconvenient judgments, inconvenient orders, there will always be somebody who may make an allegation on affidavit. And then
force someone to resign on moral
I know
grounds.
that Karuna and the others will say there was a prima facie finding by the Supreme Court. The Supreme Court finding is just that. It's prima facie. And it was made more to clear the air of suspicion as far as the other names were concerned.
KTS Tulsi, do you agree with that?
I entirely agree. You see, we can't reverse the process of presumption of innocence that is engrafted in the Constitution. It has a history of 500 years from the Star Chamber days when people could just be hanged on suspicion. You see, we have a civilized jurisprudence in our country. We can't simply presume. There is no inexorable rule of law or logic that all men are liars and their word will never be taken to be true. There is neither a rule of law or logic that all women are, whatever they say will be gospel truth. After all, these allegations have got to be tried, and we can't jump to the conclusion. Sentimentalism cannot take place of the rule of law. It will be very dangerous, and it can make everyone vulnerable. That's why there is a procedure of trial.
Let me be extremely clear about what the legal argument is here. The legal argument is that there is a certain amount of very high level due process that has already happened. 3 Supreme Court judges, evidence that was before him, a prima facie finding that there was sexual assault
That's
against
not conviction.
by a former Supreme Court judge.
Your paraphrasing is wrong.
But we are looking at an
Karuna, your
interim decision here.
paraphrasing
We are
is
looking
wrong.
at an interim decision.